Getting served with a debt collection lawsuit can feel like a punch to the gut. That sinking feeling, wondering what to do next, how to avoid wage garnishment, or having your bank account seized. We see hundreds, if not thousands, of people make the mistake of ignoring the case altogether, leading to a default judgment and unexpected garnishment notices. But you don't have to be one of them. Today, I'm going to walk you through how to write a killer answer to a debt collection lawsuit, just like a real lawyer would, so you can vastly improve your chances of winning your case. First, it's crucial to understand the type of lawsuit you're facing. Debt collectors typically file two types of cases: small claims lawsuits, which have special, streamlined rules, or cases under the regular rules in county or civil court, usually for larger amounts. The most important first step is to read the summons carefully. This document will tell you exactly how you need to respond. For small claims, you might be required to appear at a court hearing. For cases under the regular rules, you'll almost always have to file a written response to the complaint within a set period, typically 20 days. Failing to file that written response means you'll lose your case by default, exposing you to collection efforts like wage garnishment or asset seizure. Today, we're focusing on how to prepare that written response. The first step in preparing your response is to understand your theory of the case, why you deserve to win. Maybe it's not your debt or you're a victim of identity theft. Perhaps the amount is wrong or you've already paid it, or maybe they simply don't have the right to sue you because they don't own the loan, or you haven't seen any proof that you owe them money. Once you have your theory, grab the complaint and read through it, paragraph by numbered paragraph. For every allegation they make against you, you need to decide whether to admit the allegation, deny it, or admit in part and deny in part. My general approach: unless you are 100% certain a fact is true, you should generally deny it and ask the other side to prove it. If they fail to prove any part of their case, you can win. For example, if they allege something that isn't a fact but a legal conclusion like John Smith breached the contract, you can deny it on that basis. If you're not sure about a fact, like if they claim they mailed you something on a specific date, you can deny it for lack of knowledge. Do this for every single numbered paragraph. Next, you'll add your affirmative defenses. An affirmative defense is a fact or set of facts that, if proven by you, provides a legal excuse for whatever they've accused you of. For instance, a statute of limitations defense means too much time has passed and they've given up their right to sue you, even if you did owe the debt. You'll have the burden of proving these defenses. Finally, you should consider whether to file a counterclaim against them. This is where you can turn the tables. If the plaintiff broke the contract, committed a credit reporting violation under federal law, engaged in unfair trade practices, or most commonly, violated the Fair Debt Collection Practices Act, FDCPA, you can sue them back. In some cases, they might even owe you more money than they claim you owe them. Here's the critical mistake most people don't expect. Once your answer is filed, you're telling the court you're essentially ready for trial. We've seen cases where people without lawyers filed an answer and the judge set a trial for just 30 days later because they want to fast-track these claims, especially if they see the defendant doesn't have a lawyer. So before you file your answer, especially if your case is under the regular rules, you really should talk to a lawyer first. They can help you understand the procedural traps and whether you have a valid basis to defend the claim. Don't let debt collectors intimidate you. Knowing how to properly respond to a lawsuit can make all the difference. If you need help, we offer a free 30-minute consultation. Check the description for contact details. Thanks for watching, and we'll see you on the next one.